Good evening. Welcome to Vermont's Law School Embedded Racism in the Law series. I'm Shirley Jefferson, the Associate Dean for Student Affairs and Diversity and Associate Professor. Let me tell you a little something about these series. In response to the tragic death of George Floyd, Breonna Taylor, and others, several professors and I initiated a series of virtual panel discussions on embedded racism in the law series. We held many panels, including qualified immunity, structural racism in America and agriculture, unconscious bias in the classroom, and many, many more. Tonight's discussion, Advancing Environmental Justice in America, the news from Washington, D.C. I'm very excited about this presentation tonight because we have one of our former law school professors, Marianne Engelman-Lado, the Deputy General Counsel of Environmental Initiatives, the Environmental Protection Agency. She will bring us great news from Washington, D.C. We have Professor Pat Parento, Senior Counsel, Environmental Advocacy Clinic. He will make sure we receive that news. Professor Parento will moderate the question and answer series tonight. Any questions that you might have for our speaker, put your questions in the chat and Professor Parento will read them. So, Professor Parento, you have the floor.
Thank you, Dean Jefferson. And hello, Marianne. It's wonderful to see you again on the screen. And hello, everybody. Thank you for joining us this evening. The topic couldn't be any more important or any more timely. There's so much happening these days on the environmental front. When you think about the transitions underway in energy, in transportation, in land use, you think about the looming challenges associated with climate disruption, but then you think about all the conventional air quality, water quality problems. We just saw today a recent study showing that half of the waters of the United States are impaired. They're not meeting water quality standards for fishing and swimming and drinking water. And we know the communities that are most at risk from these environmental threats are the frontline communities, the environmental justice communities. And we are so fortunate to have Marianne Engelman-Lado with us, again, returning from a key position at EPA. And of course, EPA is right in the middle of everything that's happening on these things these days. It's a huge challenge. So Marianne, take it away and tell us what's going on.
Okay, terrific. Thanks so much, Professor Parento and Dean Jefferson. It's just more than a delight to see you both. What I want to do, and let me, while I'm starting this, let me share my screen. Hold on just a sec. There we go. What I want to do today is share the news from DC. And I have to say, I'm really excited to do this, and I'm really excited to have joined the Biden administration. As a starting point last January, February, I had to have really believed that there was a window of opportunity in the Biden administration to advance equity and environmental justice to leave Vermont Law School. I miss it. I miss the beautiful surroundings and the incredible community at Vermont Law School and the Environmental Justice Clinic. So there really was a leap of faith and a belief that we could try to make something happen in Washington. But I want to share why I'm more convinced than I was a year ago that we have this window of opportunity. There is incredible leadership coming from the White House and from Administrator Regan. And I want to share with you why I say that and why that commitment is being followed up by action. I'm going to talk about the steps the agency is taking to advance equity and environmental justice, and then focus in particular on the work to strengthen our civil rights program and enforce civil rights. And of course, leave plenty of time for question and answer. So to start with, and I'll go into a little bit more detail after outlining it. From the very first day, his very first days in office, President Biden made a commitment to advance equity and environmental justice by signing 2 executive orders on equity and environmental justice. The first was, or the 2 were 13985, advancing racial equity and support for underserved communities through the federal government, and 14008, tackling the climate crisis at home and abroad. And from his very first days in office, Administrator Regan issued an agency-wide directive to the EPA to better serve historically marginalized communities using cumulative impact assessment and the other tools we have, enforcement tools, et cetera, to advance equity and environmental justice. More specifically, EO 13985 made very clear that the government should pursue a comprehensive approach to advancing equity for all, including people of color and others who have been historically underserved, marginalized, and adversely affected by persistent poverty and inequality. And I just want to harken back to the starting point for this lecture series and for where we are at this moment in history. This administration came into office in the wake of all of the mobilization around the murder of George Floyd, and really takes to heart the need to address racial inequality. EO 13985 also talks about equity, and which is a broader term. And I put on the slide the definition of equity in 13985. Historically, we know that Executive Order 12898, signed during the Clinton administration, focuses on inequalities on the basis of race and income, and we'll get back to that. There's a long and sustained effort to address environmental justice, and an enormous and inspiring movement across the country by communities that have been defining environmental justice. I think of the environmental justice principles that, if you haven't read them, are available online, and also pushing administration after administration to identify and address inequalities and actions that have a disproportionate impact on the basis of race, color, national origin, and income under Executive Order 12898. In addition, the Biden administration recognized the need to address equity more broadly, including and defined equity as the consistent and systematic, fair, just, and impartial treatment of all individuals, including individuals who belong to underserved communities that have been denied such treatment, including people of color, members of religious minorities, people in the LGBTQ community, persons with disabilities, persons who live in rural areas, and persons otherwise adversely affected by persistent poverty or inequality. EO 13985 called on the federal government to take a number of actions, and one of those was that every federal agency had to look inward and assess what are the barriers to advancing equity, and then propose or commit to strategies that would address those barriers. So all the agencies have been working on that, and we expect shortly that these equity assessments and strategies will be released by the federal government and made available to the public. I'll just mention that at EPA, that goes hand in hand with other actions, such as a strategic plan that went out for comment and has been finalized, that includes for the first time a goal to advance environmental justice and civil rights that goes hand in hand with any equity plan. EO 14008 had a number of significant commitments, and this included the creation of a White House Environmental Justice Interagency Council, and that council was charged with a number of concrete activities to advance environmental justice and to ensure accountability, including the creation of a scorecard that by which the public can measure agency action. There was also the creation of the WEJAC, the White House Environmental Justice Advisory Council, with representation from across the country to advise the Interagency Council and CEQ, the Council on Environmental Quality. The WEJAC got to work right away. They have a number of committees. And I should mention that at EPA, we continue to have the NEJAC, the National Environmental Justice Advisory Council, advising the administrator and EPA on issues of environmental justice. The NEJAC also has a number of really important working groups and is meeting regularly. And our Office of Environmental Justice is active in a whole number of fronts. If people haven't already signed up for announcements from the Office of Environmental Justice and are interested, I encourage you to sign up. And also we have a monthly call with thousands of people who participate to engage on issues of environmental justice. EO 14008 also called for the creation of a climate and economic justice screening tool, also known as CJEST, which is out for comment right now. You can go to CEQ's, the White House's website, and find information about CJEST. Comments are due, I think it's April 25th, if anybody wants to comment on the tool. This is a tool to help agencies of the federal government with their commitment to what is called Justice 40. This is a commitment that the president made before coming into office and has delivered on. And the commitment is to deliver 40% of benefits of federal climate, clean energy, affordable and sustainable housing, clean water, and other investments to disadvantaged communities. And the CJEST tool is specifically designed as a tool to identify those disadvantaged communities that will get the 40% of benefits. As you may know, there are mapping tools all across the country. Michigan just published its mapping tool today, so that's hot off the presses. EPA led the way with launching EJ Screen in the Obama administration. It's a screening tool that's used to identify a number of issues, including demographic factors and environmental factors, and put them in juxtaposition to the state, the region, or the nation to identify where there are communities with environmental justice concerns. And EJ Screen is still available. In fact, this administration recently announced new information, new functionality that's in EJ Screen, and it's called EJ Screen 2.0. So mapping tools, a way of visually representing data that we have and layers of data to be able to identify which are the communities that are affected by a number of different factors that might create greater susceptibility, are really an important and exciting development in states and in the federal government that allow us to direct attention and direct resources where they are needed most. I want to just harken back to Executive Order 12898 because it continues to be a driving force for agency action to address environmental justice. And I did call this talk, or the title of this talk refers to both environmental justice and equity. And part of the reason is we are still very focused on our obligations under Executive Order 12898 and addressing inequality based on race, color, national origin, and income, as well as the structural inequality, the issues of structural inequality that are mentioned in EO 13985, this larger set of issues around equity. And let me just say a couple things before I move on from that, to call out in particular the issues of inequality affecting people with disabilities that are identified in 13985. As we look to addressing issues of climate justice, I know in my work before coming to EPA, the particular effects on people with disabilities have been highlighted in a number of states and a number of contexts. I was working with the Governor's Council on Climate Change, the GC3 in Connecticut, for example, and the very first public meeting we had before the onset of the pandemic, we had we met in a school, and we went into breakout sessions. These were actual breakout sessions, not just on Zoom. And we were talking about what environmental justice means to people and what do we have to take into account. And at that very first session, people from communities who were engaged in the conversation said that issues of climate disproportionately affect people with disabilities, whether that is people with mobility impairments, people with hearing impairments, people with psychiatric impairments, people with intellectual disabilities, people with vision impairments. If you think about who is most affected by changes in climate, one of the key factors has to be people with disabilities, people with asthma who are affected by changes in heat, for example, or air quality, people with mobility impairments or other physical impairments that might be faced with barriers on transportation or barriers of communication in getting emergency announcements or in emergency response. These are issues, and there's a substantial literature. When I was at Vermont Law School, some of the clinic students in the Environmental Justice Clinic were looking carefully at some of these issues, and these are issues we need to pay more attention to. In addition, however, I think our understanding of the way in which issues of race, color, national origin, and income continue to affect where we are today is something we have renewed attention to. And I want to draw your attention to a study that came out last week. At the end of the week, there was a Washington Post article. The study is by Lane et al. It's called Historical Redlining is Associated with Present-Day Air Pollution Disparities in US Cities. And what it is focused on is the relationship between places where there was redlining and current day disparities in exposure to air pollutants. So we see that the footprint of historic discrimination continues today in racial disparities in exposure to pollution, which coincides with an enormous body of literature around the relationship between race and income and where facilities are located, and also issues of exposure. So EO 12898 called on each federal agency to develop an agency-wide environmental justice strategy to identify and address disproportionately high and adverse human health or environmental effects of their programs, policies, and activities on what was then called minority populations and low-income populations. And that mandate applies to us today, and our leadership are taking seriously. What do I mean by that? Well, let's start with the administrator's April 2021 directive. And again, from the first day he arrived, I knew that I had made the right choice. Despite missing Vermont Law School, I knew that I had made the right choice to join the administration. Administrator Regan's directive touched on our longstanding mission to protect human health and the environment, and recognized that in order for us to fulfill that important mission, our responsibilities are to protect the health and environment of all Americans, including those historically marginalized, overburdened, underserved, and living with the legacy of structural racism. He had specific mandates for the agency, including strengthening enforcement of both environmental and civil rights laws, which in the second portion of this talk I'm going to be focusing on. Steps to incorporate environmental justice considerations into our work, including in rulemaking. And again, that harkens back to the mandate of EO 12898. Early and more frequent engagement with communities, of course, public and stakeholder or community engagement or participation is a core set of principles in the environmental justice movement and in the definition of environmental justice. And I've already mentioned the implementation of Justice 40 to consider and prioritize benefits to disadvantaged communities. One key aspect of the work to further and integrate environmental justice and equity at EPA is a focus on cumulative impacts. This focus is agency-wide, and it started in the very first days of this administration. Cumulative impacts has been called the holy grail of the environmental justice movement because it reflects the lived experience of people in communities that have a disproportionate concentration of facilities, and as a result, their health and quality of life suffers. So we have a working definition of cumulative impacts by EPA's Office of Research and Development, and ORD is taking the lead on developing the definition and has made cumulative impacts one of their priorities for research over the next few years. The definition, the working definition of cumulative impacts refers to the total burden from chemical and non-chemical stressors and their interactions that affect the health, well-being, and quality of life of an individual, community, or population at a given point in time or over a period of time. And we recognize that the combination of effects and any resulting environmental degradation or health effects are what we need to focus on, and they are the focus of ORD's cumulative impacts research. And the research is research-driven or action-driven research. That is, in addition to the longer-term further refinement of analysis, there is now a need to integrate cumulative impacts assessment into the work that we do. And by cumulative impacts assessment, we mean the process for accounting for cumulative impacts in the context of problem identification and decision-making, which requires consideration and characterization of total exposures to both chemical and non-chemical stressors, as well as their interaction over time across an affected population. So at ORD, there are recommendations for action-oriented research. ORD has released a white paper for external review that presents recommendations on how to strengthen the foundation for assessing cumulative impacts. And I should just note that the recommendations were developed by a work group of experts, but as a result, in part, of listening to experts and community voices from across the country, including representation from 65 tribes, 62 state agencies, 35 local agencies, 9 national associations, academics, and others. So let's see this in action. I want to focus for a second on a letter that the administrator sent on May 7th, 2021 in the General Iron matter. So General Iron was the largest metal shredder in Region 5 of EPA. The facility was originally located in Chicago's predominantly white and affluent Lincoln Park neighborhood on the north side of Chicago. It faced strong community opposition, had a record that will speak for itself if you check it out. And in September of 2019, there was a set of decisions that the operation would cease operating in Lincoln Park at the end of 2020. And a new iteration, it's not the same facility, and I want to be clear about that, but a new iteration would reopen. And it would reopen its General Iron 3 in a also called Southside Recycling, in a predominantly Latino neighborhood, and it faced a lot of opposition. So you can see how the administrator described the Southeast Chicago neighborhood in a letter to the mayor of Chicago, saying that it epitomized the problem of environmental justice, said that it noticed that the neighborhood currently ranks in the highest levels for many pollution indicators on EPA's EJ Screen tool, including fine particulate matter, traffic proximity, lead paint, etc. I will note that when I joined EPA, the community was fighting the relocation of the facility. They filed two civil rights complaints, one against Chicago that was filed with HUD, Housing, Urban and Development, and one against the state for its previous decision to approve a permit related to the facility with EPA, and that Illinois EPA complaint is still pending. Both complaints are still pending, have been accepted for review, but are still pending at the agencies. In June 2020, Illinois EPA issued in the last administration, issued the proposed Southeast Side facility a Clean Air Act minor source construction permit. Before the facility could be constructed and operated, though, the facility had to receive permits from the city of Chicago, including a special permit from the city's health department. In response to the community opposition and the letter from the administrator, the city halted processing the final permit when it decided to look into the potential environmental impacts of the proposed facility in conjunction with existing facilities. And this is where we start to get into an application of thinking about cumulative impacts near or in proximity to or at the same site. The city indicated it was ready to move forward, but after receiving this letter from the administrator and hearing from the community, the city put a pause on its decision. So this slide has more of the letter from the administrator, strongly recommending that the city complete an environmental justice analysis, such as a health impact assessment, which is one mechanism for evaluating cumulative impacts, evaluating relative impacts, to meaningfully consider the aggregate potential health effect of the proposed facility on the southeast area of Chicago. In this case, the city did in fact decide to put a pause on the permit and conduct a health impact assessment. And our regional office provided some technical assistance to the city in that effort. Last month, the city denied the permit, citing both the history of noncompliance at the earlier site and risks to the health in the Southeast community. I also just want to note another way in which the administrator has led on these issues. And in November of 2021, the administrator visited locations in Mississippi, Louisiana, and Texas to speak with people, to listen, to tour sites, but then followed up.
Tomorrow and
needs to mute. I'm hearing a second person.
I don't know if Teresa tried to reschedule you.
I think that's Dean Jefferson. Okay, thank you. And so the administrator followed up with concrete steps, including the Office of Enforcement and Compliance Assurance to use its authority to conduct unannounced inspections at suspected non-compliant facilities, launching a new monitoring project, the Public Pollution Accountability Team, that combines monitoring with inspections, and grants to enhance local air monitoring in communities. Okay, I want to switch to that general overview of the first year and both the commitment to environmental justice and equity and some of the steps to implement or execute that commitment, and talk more specifically about the commitment to strengthen civil rights enforcement in the environmental area. I'm going to focus on Title VI of the Civil Rights Act of 1964. EPA enforces, as every agency enforces, a number of different civil rights statutes that are applicable to recipients of federal funds. But we get most of our complaints about allegations of discrimination on the basis of race, color, and national origin, which are violations which are allegations of violations of Title VI of the Civil Rights Act of 1964 or agency regulations. Historically, EPA has been noted for its poor record of civil rights enforcement. And if you have read my material, you'll know that one of the areas of focus in my own research has been to try to understand the variation in effectiveness of civil rights enforcement across agencies. And from really the early days of EPA in the 70s and certainly then in the 90s and more recently, there has been criticism of EPA for failing to enforce Title VI in a meaningful way. EPA historically during the 1990s tried to get civil rights enforcement off the ground, but pretty quickly there were some riders from Congress that limited its ability to use its funds to enforce civil rights, which really put a damper on civil rights enforcement that exists to this day. And we really need to finally catch up with our sister agencies, harmonize the way in which we do civil rights enforcement, and make clear that the Civil Rights Act of 1964 and agency regulations apply in the environmental sector as well. Just to give you one taste, and there's a very large literature of that digs into EPA's poor record, and I use the word poor record as that phrase as a quote, because when Lisa Jackson came into office as administrator during the Obama administration, she asked the Deloitte to do an internal audit of EPA's civil rights program. And while they didn't look at the substantive standards we were using, they looked at management and training and capacity, and it was their words that EPA had a poor record in its civil rights program. So we are charged with turning that around and bringing the promise of the Civil Rights Act and civil rights enforcement to the environmental sector. So what do I mean by that? Well, let's start with the statute. Title VI says no person, Title VI says more than what I'm about to share with you, so I encourage you to go to the statute. But it says no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. And then the next section of Title VI authorizes agencies that disperse federal financial assistance to pass regulations and be responsible for enforcing Title VI. Executive Order 12250 also gives the Department of Justice coordinating responsibility across the federal agencies. And why do I mention that? Sometimes in the environmental sector, there is this, and through the environmental justice movement, there is a focus on civil rights enforcement at EPA as if it's somehow different or novel. But in fact, the federal government enforces civil rights across the agencies, the Department of Education, the Department of Health and Human Services, and we have catch up to do. We're not out in front, we have catch up to do. So there are a few things I'm going to note in the next few minutes about Title VI. Let me just preview them. The prohibition against discrimination, exclusion, and denial of benefits runs to all people. You don't have to be a citizen to have protection against discrimination under the Constitution or under Title VI. It prohibits discrimination, exclusion, and denial on the basis of race, color, and national origin. This distinguishes it in a number of different ways, certainly from environmental justice, which also asks the federal government or requires the federal government to evaluate, identify, and address where our policies and practices have a disproportionate impact also on the basis of income. So Title VI prohibits discrimination on the basis of race, color, or national origin. It is broad in scope. It doesn't only prohibit discrimination, but also prohibits exclusion and denial of benefits. And it applies to any program or activity receiving federal financial assistance, not just the use of federal money, but the whole program or activity that receives federal financial assistance. Every agency that disperses federal money is authorized to pass rules to effectuate Title VI. And most of those regulations are substantially the same. There were coordinating regulations by the Department of Justice, and the agencies essentially patterned their regulations after the Department of Justice. So EPA is not an outlier on this. EPA regulations require programs or activities receiving EPA assistance to or prohibits from directly or through contractual licensing or other arrangements on the basis of race, color, or national origin to subject people to segregation or separate treatment, to deny people the opportunity to participate as members of a planning or advisory body. That might be a planning body at a local level where the locality receives federal funds, to use criteria or methods of administration which have the effect of subjecting individuals to discrimination. Again, that's really important, to having methods of administration which have the effect of subjecting individuals to discrimination, or choosing a site or location of a facility with the purpose or effect of excluding individuals from, denying them the benefits, or subjecting them to discrimination. Our regulations also outline the administrative process for filing, investigating, and resolving complaints of discrimination, and also for initiating investigations even in the absence of complaints. As I mentioned earlier, there are other prohibited bases of discrimination under Section 5 of the Rehab Act. That's disability, age discrimination, Title IX of the Education Amendments, to the extent there are educational programs involved, which prohibits discrimination on the basis of sex, as well as the FWPCA, which are programs or activities receiving financial assistance under the Clean Water Act. As I mentioned, the prohibition applies, or the protection applies to any person. And so person carries a broad meaning under the Constitution and under Title VI. The prohibition is also broad. It protects people from discrimination on the basis of race, color, and national origin, which also includes language. And in 1974, the Supreme Court in Lau versus Nichols found that providing language service is part of the obligation under Title VI not to discriminate based on national origin. EPA interprets its Title VI regulations to require all recipients of EPA assistance to provide meaningful access to persons with limited English proficiency. And that term, limited English proficiency, is sort of a term of art. It's also called LEP. And of course, EPA's own programs or activities must also be accessible to people who are LEP. I just wanted to note that federal financial assistance to come under Title VI and other civil rights laws, also called spending clause statutes, isn't limited to grants. There are other kinds of federal financial assistance, which would then oblige recipients of federal financial assistance to comply with Title VI. And as I mentioned, program or activity also should be understood broadly. We're not just tracing the money and saying, okay, if you got $5 from the federal government, you can't discriminate in that $5. It's the program or activity that receives the $5 that can't discriminate in its programs or activities. Okay, and what do we mean by discrimination? There are a number of different types of discrimination, as you already heard from the discussion of our regulation. And again, that regulation maps regulations across the federal family. So the prohibition is not only against intentional discrimination, but actions with an unjustified disparate impact, denial of language access, and there's also a prohibition against intimidation and retaliation. So what do I mean by intentional discrimination? Without going into a lot of detail, there are different theories or different ways to prove intentional discrimination. If you're interested in this and haven't looked at it before, I highly recommend the Department of Justice has an updated Title VI legal manual, and it has a chapter on intentional discrimination and a chapter on disparate impact, and it has a lot of citations to the underlying case law that inform those chapters. But very briefly, intentional discrimination can be proved using direct or indirect evidence, individually or together. And types of circumstantial evidence might include suspicious timing, inappropriate remarks of a decision maker, departures from normal procedural evidence or statistical evidence demonstrating a clear pattern of discriminatory impacts, although discriminatory impacts by themselves aren't sufficient to form a claim of intentional discrimination. There are other ways to show circumstantial evidence of intentional discrimination. And I encourage you to take a look at that and dive more deeply into it. How do we look at a disparate impact claim? What do we mean by that? We mean that a recipient of federal funds has a facially neutral policy, that it doesn't say we're treating on its face that we're treating one group of people on the basis of race, color, national origin different than the other, but it has an adverse impact that is felt disproportionately on the basis of race. The affected community, if you look at the racial composition of the affected community, it's statistically different than the universe of potential affected people or the unaffected population. So I just have a slide here about a disproportionality analysis that was done in a case that I worked on before I came to EPA, but EPA also issued a letter of findings around, and the case was ultimately settled. This was a challenge in North Carolina to a swine permit that permitted the swine waste management systems in more than 2,000 facilities in Eastern North Carolina. And expert named Steve Wing, who has since passed away, but taught epidemiology at UNC Chapel Hill, and Jill Johnston, who's now teaching in California, they did an analysis of where the facilities were located and whether they were whether there was a relationship with the percentage community of color and the racial composition, racial and ethnic composition of people living within 3 miles of the facilities. The dots you see, the little black dots you see, are swine facilities. The color of the land is racial composition. The reddish color is the highest percentage, over 40% people of color. I'll note that Western North Carolina is mountainous and inappropriate for swine facilities, so that was sort of grayed out. But the rest of North Carolina was considered as a potential area where a confined animal feeding operation or a hog facility might be located. And they looked at the relationship and found a very strong relationship between where those facilities were located and the percent people of color. And they also looked specifically on the percent African Americans, percent Latino, and percent Native American. In fact, the strongest relationship was with percent Native American. And you can see in that place where there are all those black dots, that's Duplin County and Sampson County, 2 of the counties in the country with the greatest concentration. Actually, they are the 2 counties in the country with the greatest concentration of swine facilities. You wouldn't be able to see anything underneath if you adjusted the size of the dot for the size of the facility. There are just so many hogs in that area. And I'll note that this doesn't even look at the cumulative impacts or potential cumulative impacts with the poultry industry, because many poultry facilities are co-located there. So that's what that visual is about, is in that case, there was an identification of what are the harms, and then what are those harms felt disproportionately by the affected community. In that case, it was defined by people living within 3 miles compared to the area where facilities could be located or the general population. And these are just 2 pictures without spending a lot of time. These pictures were shared by the complainants, raising concerns about the impacts of the swine waste management permit on waterways. This is just by way of illustration. In this case, community groups raised concerns about smell, impacts on health from airborne contaminants, interference with quality of life. The picture on the left is a spray field where swine manure is sprayed, but you can see that sort of herringbone and the line of the spray field that is waste going toward at the bottom left, that's Stockinghead Creek. And you can see the waste just pouring out towards Stockinghead Creek. And on the right, you see oversaturated spray fields. Okay, if a disparate impact is identified, that's not the end of the story. That doesn't mean there's a violation. The recipient of federal funds can articulate a legitimate non-discriminatory reason for the choices or the decision or the action or the policy or practice that they made. If, however, there is a less discriminatory alternative, and I'm looking on the right at the disparate impact claim, then that asserts a violation. So the substantial legitimate justification can be overcome by an alternative or a less discriminatory alternative. And then there would be a violation established. In addition to the disparate treatment and disparate impact, as well as language access and retaliation or intimidation claims, there are also requirements that are called procedural safeguards, that in order to ensure that there isn't exclusion or denial of benefits, particularly exclusion, our regulations require that recipients of federal funds have a notice of non-discrimination, have grievance procedures, have a non-discrimination coordinator, and ensure access to programs and activities by persons with limited English proficiency. Okay, so what do we do when I hearkening back to my point that historically there were many good people trying to do many good things at EPA, but it had a poor record of civil rights enforcement, and we want to strengthen civil rights. What do we do to achieve compliance? So the activities of the external Civil Rights Compliance Office, and just in terms of terminology, historically EPA had one Office of Civil Rights with internal or equal employment work, as well as external civil rights compliance work, which is the enforcement of Title VI, the enforcement of civil rights as to recipients of federal funds. At the end of the Obama administration, those split into two offices. The civil rights or internal EEO work is done by the Office of Civil Rights, which is within the Office of the Administrator. The external Civil Rights Compliance Office is within the Office of General Counsel, where I have the great opportunity to work with them. So we're more focused today on the substantive obligations and prohibitions. And what do we do to make sure there's compliance with both the procedural and the substantive obligations? Well, one is making sure that recipients of federal funds know what the expectations are. And that is done through a lot of technical assistance to encourage compliance, training programs, guidance documents, all kinds of ways to ensure that recipients of federal funds have information. We also want to make sure that communities know their rights, and we are pushing for more engagement with communities, and I'll talk about that in a minute. There's a pre-award process. So before recipients of federal funds are granted, they are approved for an award, they go through a pre-award process, and there's a form where they fill out. It's called a 4700-4 form, and they have to say whether they have a language access policy or plan or practice, whether they take data to ensure that they are complying with civil rights laws, et cetera. And the agency reviews those forms and works with other offices to decide whether they are qualified, they meet the standards of civil rights compliance to get awards, or they're not. And so that's an important piece. EPA, the piece that's gotten the most attention is complaint investigations. Communities that are concerned about civil rights compliance can file a complaint. Over the course of the history of EPA, there have been something like in the order of magnitude of 300 complaints. There's a website at the Center for Public Integrity that has a database with complaints that were filed between 1998, I believe, and 2014. Vermont Law School's clinic has also been working to make additional information available, but EPA is now working to also make its the complaint it receives and the status of those complaints available on our website. We have a chart that we've put on our website, and the goal is to make that a more robust place for information in the coming time. But complaints have gotten the most attention because there are communities that are aggrieved and want a result. And EPA receives those complaints. There's a case resolution manual that's online that explains how those complaints are processed. EPA is supposed to acknowledge a complaint within 5 days. We're obliged to, under our regulation, do a jurisdictional review to ensure that we have jurisdiction over the complaint. That is, the complaint is in writing. It's against a recipient of federal funds, that it alleges a case under, or a claim that is cognizable under the regulations. And I'm missing one for right now, but and we do that jurisdictional review within 20 days or thereabouts. And then we have 180 days to conduct an investigation. That 180 days is frozen if there are negotiations under alternative dispute resolution or other processes to resolve the complaint. We also have the authority to do affirmative compliance reviews. We don't have to wait passively for a complaint. And so if there is reason to believe there are violations or non-compliance with agency regulations, we have the authority to do compliance reviews. And as I mentioned, there are various forms of ways to seek resolution. We can support alternative dispute resolution between the complainants and the recipients. We can get into a room and seek informal resolution with the recipients of federal funds. Or if we go through an investigation and make findings and there hasn't been informal resolution, we can seek, we are actually obliged to seek voluntary compliance under our regulations and under the statute before aiming to withhold federal funds or refer a case to the Department of Justice for further processing. On September 28th, 2020, in the last administration, the Office of Inspector General at EPA issued a report reflecting those same longstanding concerns that I talked about earlier. And again, it comports with my own research that a lot needed to be done to ensure that there was a change of culture, both inside EPA and outside, to recognize the applicability of civil rights and change the way in which we do things accordingly. And so the Office of Inspector General made 6 recommendations to ensure that the program is reviewing compliance in a more comprehensive way, that the program is, and EPA is providing clarity of expectations through guidance and taking other actions to have a strong civil rights program. So here are just some of the steps we're taking. And I'll just note that until the last few days, we've been operating under a continuing resolution with no additions to staffing at EPA. And it's a matter of fact that we have something like 12 full-time equivalent positions in the External Civil Rights Compliance Office to process complaints, do trainings, meet with communities, put out guidance documents, et cetera. Even under the new budget, that hasn't changed yet. So stay tuned for that. So what are we doing to strengthen civil rights? And this will be my last, not my last slide. I have a couple more slides, but the last sort of point I want to make, which is what can stakeholders expect in the days to come? So, we made commitments to the Office of Inspector General to take their recommendations and put them into action. We also made commitments in Goal 2 of the draft strategic plan to prioritize environmental justice and civil rights. So we are moving from a reactive stage to proactive. Now, it's still reactive in a sense. We still have, I think we have something like 34, I'm not sure what the exact number is, but complaints right now on our docket, in addition to complaints in the monitoring stage. So to the extent receiving a complaint is reactive and we have 12 people, some of our work is going to continue to be reactive. But where we can, to become more proactive, to strengthen our pre-award review process, to communicate expectations to recipients of federal funds. We had our first listening session with communities in October of last year. We took to heart input from communities, and we also developed the first guidance or document that we rolled out was to provide transparency in how we'll prioritize in determining where to do compliance reviews, that these affirmative investigations or fact-finding, and what would be the process for determining priorities and what would be the criteria. You can find that on the External Civil Rights Compliance Office website, and to start initiating compliance reviews. As I mentioned, clarity and transparency are really important. We have that document about compliance reviews out, and shortly we hope to be issuing the next guidance to stakeholders, which will be about procedural requirements. And then we've committed to the Office of Inspector General to be issuing a guidance on what we're calling a programmatic guidance on substantive standards. And we're doing a lot of work to ensure we have greater transparency of our docket. We also want to make sure our work is consistent with principles of environmental justice and integrated with the environmental justice work across the agency, and truly integrated with all the work across the agency. We're giving out grants. Those are opportunities to lift up or help recipients of federal funds to anticipate their obligations under Title VI and other civil rights acts. I mentioned our first listening session, and we're developing ways to engage communities on a more regular basis, not just communities that file complaints, that's important too, but also engaging communities to make sure we have clarity about what we are doing. We're also expanding alternative dispute resolution in various interesting ways. So historically, there was alternative dispute resolution, which allowed community complainants or complainants and recipients to get in a room together. We actually used that in the North Carolina case, wearing my old hat. It's actually where I first met the administrator. He was the secretary of DEQ, the Department of Environmental Quality in North Carolina, and he was on the other side of the table. And I was representing community organizations in that negotiation. EPA was not involved, although EPA paid for a mediator. So that's the sort of traditional alternative dispute resolution approach. EPA also had informal resolution where EPA got into a room with the recipient and engaged in negotiations to find a resolution. But there have to be ways to bring us all together as well, which may be appropriate for certain kinds of complaints. And all these 8 alternative dispute resolution approaches are voluntary, and so they're offered to recipients of federal funds as a way to resolve a complaint rather than having a full investigation. And finally, there's so many things to talk about, but I want to make sure we have plenty of time for Q&A. And the last thing I want to talk about is an all-agency approach, the importance of integrating what we're doing in EPA's programs and regions. That involves training, it involves discussion, it involves addressing particular barriers. These are some resources I talked about. Of course, we always start with the statute and the regulations. I want you to know that we already had, due to work over time, guidance documents on obligations by recipient of federal funds to make sure there's language access to ensure accessibility for people who are LEP. There's also a Title VI public involvement guidance for EPA recipients that was put out in 2006. There is an EPA order about our own compliance or LEP access. And I mentioned the DOJ Title VI legal manual. And I also mentioned the case resolution manual, which you can find on EPA's website. With that, I'm going to, I hate to stop just on a note of resources. Let me just say that I am both excited to be here and excited for the work we're doing in EPA. I hope I've shared some of that excitement, and I welcome your thoughts and questions.
Wow. Did we get our money's worth or what? Thank you, Marianne. That was just terrific. I mean, honestly, I don't think anybody would have had the breadth and depth that you do on these programs. You've been a pretty serious critic of EPA's enforcement program. So the fact that they've hired you and put you inside the tent, I think is a really good sign. And it sounds like there's an awful lot happening. I do have a couple questions in the chat, but first, I was going to pose this conundrum for you. You know, and this is background for the audience, some of which will be familiar to people, but maybe some of it not. You know, most of our environmental programs are carried out by the states. So EPA delegates an awful lot of authority under all the statutes: Clean Air Act, Clean Water Act, Safe Drinking Water Act, and a lot of these federal laws give states, you know, either primacy or certainly first crack at permitting and enforcement. So the question is, you know, waiting for someone to complain about what a state has done through one of the delegated programs is a little late. I'm sure you would agree. And so trying to get ahead of that and get the states up to speed on what they need to be doing in the administration of these federal programs is obviously important. I've noted that already Administrator Regan, under his leadership, has taken a couple of interesting actions in that regard. With regard to Missouri's Department of Natural Resources, he's basically put them on notice, as I read it, that they're really not, their public participation program is not up to snuff when it comes to you know, addressing EJ issues. And recently I saw that there was an action taken with regard to the city of Chicago and the sighting of a major scrap waste vehicle facility in an EJ community. So I guess the question for you is, is EPA beginning to reach out to the states in what looks to be a coordinated way of saying, we're going to be looking at the way that you're administering our programs, not just from the day-to-day sort of bean counting, how many permits do you issue, how many inspections do you take, but rather, how are you really embedding, if you will, these environmental justice principles? So what, can you tell us a little bit more about how you're getting out in front of that?
Yeah, let me say a few things. First, I appreciate I don't know if it's compliment or not, but the comment about my background and how it's a good sign. But I just want to say how many terrific people I work with. I mean, I already talked about how proud I am to work under the administrator, but I have to say both my colleagues who are also appointed and also the career folks are just outstanding. And I think you're already familiar with that, Professor Parento, but I'm just so impressed with the level of dedication and commitment to environmental justice and to strengthening the civil rights program and to issues of equity and just to all that we do to carry out our mission. So I am not alone. That's one of the things that I'm just so excited about, that it was a leap of faith for me. I had never worked for the government since I was in law school, and I had I had never worked for the federal government, and the closest thing I had ever done besides sort of visiting the government was working for a DA's office during law school. So it really was a leap of faith, but it has more than exceeded my hopes in terms of not being alone out there and really having the support and common mission with the agency and with my colleagues. You're absolutely right. Environmental programs are carried out by states, and in many cases, federal laws give states primacy. I have to say that on environmental justice, some of the states are ahead of the game. I think about Michigan putting out its screening tool today. Rhode Island has got an EJ bill. Virginia passed an EJ law. California has a number of EJ laws in Cal EnviroScreen. New Jersey has its cumulative impacts approach. There's a lot of work going on to catalog all this, but there is a lot happening in the states, and so I would not think of or assume that states are behind the 8 ball or that it has to be adversarial, but rather we have to learn from the states. We have to partner with the states and really think about how we can support the states' work and think of the states as partners in ensuring compliance with civil rights and moving forward on environmental justice. Keep in mind also, and just to sort of do a footnote to the civil rights piece, that recipients of federal funds, which are often states, also have an obligation to ensure compliance by subrecipients. So that is, if we give a grant, for example, to a state, they are supposed to ensure compliance with their subrecipients if they give to a locality or whatever. And so there too, we have a partnership that we need to pay attention to. One of the things that the Obama administration tried to clarify, but I think continues to need clarification, is that civil rights obligations for recipients of federal funds are independent of compliance with environmental obligations. There was what they called a chapter of a toolkit that came out by way of clarifying standards under the civil rights law and our regulations in the closing days of the Obama administration. And it made clear that compliance with environmental laws does not mean necessarily compliance with civil rights laws. So even if there is compliance with the NAAQS, the National Ambient Air Quality Standards, or SIPs, or whatever it might be, there may still be a violation of Title VI of the Civil Rights Act of 1964. So it's really important for EPA to be sharing that information with the states, to be clarifying what Title VI requires so that they can get ahead of it. They don't want complaints either, right? So they can anticipate, well, what are these standards? What are our obligations? What do we need to do? And I want to say that the states have been partnering on getting information out. We've been doing some training through ECOS. There's an EJ steering committee that we've been in dialogue with. So there's a lot going on. And even way before I got to EPA, one of the things actually during the last administration that the External Civil Rights Compliance Office did was to talk to states. They have like a 3-hour training they did with Vermont, in fact, to ensure that the states have these procedural requirements in place so that they can be assured that they're taking the right steps. You mentioned General Iron, which I had talked about earlier as well. And I think it's a really great example of that kind of partnership that the administrator did reach out to Mayor Lightfoot, and they did have a conversation, and then EPA provided technical assistance. The decision-making was all in the city's hands. They were the decision maker around the permit, but ultimately Mayor Lightfoot reviewed the health impact assessment, reviewed the facts, and denied the permit. So that was a partnership. That was a decision that the city made. And ultimately, cities and states are making decisions about permits and all kinds of decisions every day. Together, we can try to achieve environmental justice, and no single agency can do it alone.
Good. There's this thing called a performance partnership agreement. Maybe you could say another word or two about that tool.
Well, it's funny, I just was talking about Vermont, and there are a number of different tools by which EPA puts into writing its relationship and expectations. And we often think about regulations as a way of putting into writing our expectations or guidance documents. But this 4700-4 pre-award review form is one that applicants of federal funds, and this is just in the Title VI context, need to fill out. And if they don't fill it out or don't comply, then they can't get their federal funds. So that's one way of explaining expectations. Terms and conditions of grants are another way. there's a document called Terms and Conditions. And that has a number of different requirements. And if recipients of federal funds or states are receiving grants, they need to sign off on those terms and conditions and can be held accountable. And it was a really big and significant move forward that the performance partnership pieces included civil rights as well. And I know that in negotiations, and this is not something I know from being at EPA, but when I was at Vermont Law School and we were having discussions with the state of Vermont about their interest in moving forward on a language access plan and their interest in moving forward with a public participation plan, it was because they had received technical assistance from EPA, but even perhaps more importantly, they had this requirement as a condition of getting money in the performance partnership plan to make sure that they had a language access plan and a public participation plan and fully complied with Title VI. So these are important tools to ensure compliance. And I just want to circle back to the Office of Inspector General's report again, because one of the things the Office of Inspector General said is, look, all 50 states should be complying with these basic procedural requirements. And so putting the requirements into performance plans and terms and conditions and then enforcing that is a way to make sure it's systematic and not just dependent on who files a complaint.
Right. We do have a question from one of our students, and it goes back to your discussion. I think it was slide 25 on disparate impact. And the question is, sort of more detail on how difficult is it to prove that? And, what's been the track record? Are these hotly contested cases when this comes up, or are they relatively straightforward?
Well, let me start with how difficult disparate impact is in other contexts. And, difficult is a funny word because it's totally case dependent. There may be hard cases and there may be easy cases that may be easy to get facts and harder to find the facts, right? But it is routine to have disparate impact cases in other contexts. You think about whether or not tests have a disparate impact on the basis of sex. There was a case in the courts about using the PSATs for national merit scholarships and whether it was a valid indicator of future success. And I think it was a case called Sharif, if I remember correctly, where the court said, no, it can't be used that way. It had a disparate impact on the basis of sex in violation of the law. In that case, Title IX, I assume. And so this is routine. Testing and tracking programs that have a disparate impact on the basis of race. There's a use of, gifted and talented programs, the use of a test that isn't valid, or in the cases of employment discrimination, disparate impact is routine, right? If there's another sex discrimination claim is, for example, height and weight requirements for firefighters and whether or not those were valid and they had a disparate impact on women who may be tough and may be strong, but they tend to be shorter. And so, are height requirements necessary for doing the job of firefighting, or were they sort of a legacy of the fact that this was a male industry for such a long time? So, so this is routine. It's not particular to the environmental context. I think one of the challenges is that EPA didn't have a strong Title VI program, and we weren't around in 1964. EPA was started in 1970. It didn't develop that program, and so there wasn't sort of a routine of understanding how to implement both a disparate treatment case and also a disparate impact case. So the first cases came around in the 1990s. Now I feel like I'm sounding like a professor. I think it's talking to all of you rather than.
Be careful.
I'm sorry. But in 1998, there was a case called Select Steel. And the question in that case, there was a new permit for a new facility. And admittedly, in the permit, it said that there was going to be mercury that was emitted. There was going to be lead. We know there's no safe level of lead, but there was going to be lead emitted. And the community in Michigan said, disparate impact. There's going to be an impact. It's going to disproportionately affect people of color. This was in Flint, Michigan, in a neighborhood that was already had a concentration of facilities, and they said it wasn't justified, and that there was a less discriminatory alternative. EPA never got to the justification and less discriminatory alternative, because what they said was that there was no cognizable impact, that because the permit was going to meet the environmental health standards under environmental laws, they weren't going to take cognizance of any impact of additional mercury or additional lead. That has led to really the paralysis of disparate impact cases at EPA, which is why it was so important at the end of the Obama administration that this toolkit came out that said compliance with environmental laws is not necessarily compliance with Title VI, which should open the door for having a more reasonable approach to what is an adverse impact. It can be property values go down, it can be interference with quality of life, it can be any number of types of impacts. So yes, we have to do a thorough investigation. Yes, we'll have to follow the evidence where it goes, but should disparate impact claims be virtually impossible in the environmental sector only because if it's a new permit, they're always going to say they're going to comply with environmental standards. And if there's a history of violations, well, once you point out the violation, they're going to correct it, right? So that sort of was a catch-22. You could never find an impact. And that's not the way it's supposed to work. That's not the way it works in any other sector. And in theory, that there was clarification at the end of the Obama administration, but there was never really an opportunity to move that forward. So through our guidance and through our actions, I'm hopeful that we can communicate what the proper approach is under civil rights law, and we won't have we'll follow the facts where they lead, but we won't have a virtual impossibility.
Very good. How about some tips and pointers for lawyers and of course our students who are about to become lawyers in getting involved in the Title VI process? You've done a great job of describing what it is and how it's structured and what its purposes are and so forth. But for the average, lawyer who doesn't, practice civil rights law or even perhaps specific in EPA programs, but they have clients. They may be community clients. They may be business clients, for that matter. What can you tell them so they can learn how you navigate in that process?
Okay, so one thing to know is, as a result of a 2001 case, Alexander versus Sandoval, lawyers can or communities can only go to court to bring a claim of intentional discrimination. So if there is a claim of intentional discrimination, a non-frivolous claim of intentional discrimination, the clients can consider whether to go to court. And, like with anything, lawyers need to counsel their clients as to what the options are, and that's an option for a claim of intentional discrimination. It's also an option for a claim of retaliation and intimidation, which has an intent. Sorry about that. If, however, there's no intent claim, it is a claim based on a theory of disparate impact, that there's an unjustified disproportionate impact on the basis of race, color, and national origin. Then, as a result of Alexander versus Sandoval, the ruling was that there's no private right of action to go to court. So the agency has regulations, and there are violations of the regulations. And so the practice is to file a complaint with the agency that gave federal money to the alleged discriminator, to the recipient of federal funds. And so the practice tip is to do some research. Of course, if the group is pro se, that there should not be a high bar to filing a complaint. There should not be a high bar to filing a complaint anyway. But if, as a practice tip, when I was practicing, we'd want as strong a complaint as possible. So the jurisdictional elements are to file within 180 days of the action, policy, or practice taking place that is allegedly discriminatory, that the complaint must be in writing, that it must assert a claim that if true would be cognizable, and that it's against a recipient of federal funds. So, you know, the work would be to make sure that the alleged discriminator is a recipient of federal funds. If you had, for example, a decision by a local water authority, not clear whether it's a recipient of federal funds. So there's a website called USA Spending, which is a good starting point to find out whether it's a recipient of federal funds. So you do that research, and then you want to really walk through, is there a harm? You know, what are the elements of a disparate impact case? Is there a harm? Was it felt disproportionately on the basis of race, color, national origin? Is there a justification for it? Is there a less discriminatory alternative? So you can sort of walk through that. And the harm has to be causally related to the neutral action. So you walk through that and get as much evidence and documentation as you can. Ultimately, it's the agency's responsibility to conduct the investigation. But as a lawyer, the stronger the complaint, the more convincing it will be, and the more guidance that the agency will have to be on the right track with the investigation and to know what the concerns are of the community. I started practicing at the NAACP Legal Defense Fund in the late 80s, and I was doing Title VI work. And I think my very first case was against St. Luke's Roosevelt Hospital Center, and I filed a complaint with the U.S. Department of Health and Human Services. And we called the regional office and said, this complaint is coming. We called and said, let us know if you have any questions about it. We did our research. We got experts. We sent in witness lists. Ultimately, it's the agency that does the investigation, but they're not going to know as much as you know, at least not at the beginning. So as a lawyer and as someone at an agency, you know, I already mentioned we have 12 people. The more you can provide information to the agency, the more feasible it's going to be for the agency to really get a handle on the issue. When I practiced before coming to the agency and even in the clinic, it was really important to be honest with the clients about expectations, to prepare the clients if they were going to have the opportunity to talk to EPA or the federal agency doing the investigation. It was important to pull together the strongest evidence we had. Important to be honest in all of our dealings with the recipient, with EPA, with the clients, with everyone. You know, so those are some of the starting points that I would think about in preparing for a Title VI case.
Good. Are there common mistakes that lawyers are making in accessing the Title VI complaint process? I mean, there are some really detailed procedures, right, that you must follow. So is there anything that sort of pops out as, you know, lawyers continually sort of not understanding what they have to do, or when a claim is ripe, and, you know, and so forth, that sort of thing?
Yeah, I'm trying to think of what's something that is obvious. In the area at EPA, I mentioned that there have been a few hundred over the course of EPA, so it's sort of it's a low end. It's a low number over years. So what is a common mistake? Certainly there are, I don't know that it's lawyers who have done this. I've spent time looking at all those complaints to try to understand. If you go to the Center for Public Integrity's website, you see many of the complaints were dismissed because they were untimely or they didn't assert a claim. Many of those were pro se, and they might have asserted a claim, for example, that there was, or it may have been not even asserting a claim, it may have been a description that I'm in this neighborhood, Newark or Flint or wherever it might have been, and the state is doing something to me as a community member. I'm in a poor neighborhood, and it's clear when you read that, and knowing the facts, or if you look at EJ Screen, you want to look at the demographics, that the community was disproportionately a community of color, and 10 to 1, if I had called that person to say, do you believe that you're discriminated against only on the basis of income or also race? They probably would have said race, or even looking down further into the letter, it may say something about race, but they haven't teed that up. And so like any good lawyering, to look at the elements of a claim and then to do the research and write the complaint or any brief or whatever it is you need to do so that it aligns with what the decision maker needs to decide, the elements of the claim. I know that's really basic, but a lot of cases have been rejected because they simply weren't aligned with what the elements were.
Yeah. So does EPA provide a guide for communities on this, or a webinar, or any kind of assistance in figuring that stuff out?
Great question. There are various trainings. The Department of Justice does a Title VI training regularly, and within our resources, people go to various events and provide information. Certainly, EPA goes to meetings of the NEJAC and provides information, upon request or as appropriate. And there is other information that's out there, like on the procedural piece, and this is probably more helpful for the lawyers than for most people who are doing this work pro se. That case resolution manual, while it's just procedural, it doesn't give the substantive standards, is really useful to understand what are the procedures. So, and then the guidance on language access, really useful to understand what are the requirements of language access. So there is a lot that's out there. The website is something of a one-stop shop, but not, if I were in a community and really trying to understand what the obligations were, I'm not sure it's enough of a one-stop shop, but we're working on that. As a lawyer or as a law student, the one-stop shop that I would look at is the DOJ legal manual. But it's a legal manual, the Title VI legal manual. And, it's really not, the intended audience is not the pro se community member.
And that's online, I take it, accessible. Yeah.
Yes.
Well, this has been terrific. Let me check. I don't see any other questions in the chat. And I know that you probably have other things to do with your evening. Are you going to make your slides available for folks?
I'm happy to do that. I think I sent
that
a
would be
copy of the slides, and you're welcome to share them. And let me just say what a pleasure it is to see you, Professor Parento, and you, Dean Jefferson, and to have the opportunity to talk with you.
Oh, well, it's been a great pleasure. We're going to get you back. We're not letting you go forever, okay?
My
Dean
pleasure.
Jefferson, I'll turn it back to you for some wonderful words of wisdom to close us out.
Well, thank you. Thank you. Both of our professors, it's been enlightening. The environmental justice movement goes right in hand with the civil rights movement. And I'm so glad that now we acknowledge that. And I'd like to thank you for all of your hard work, working with the Biden administration. I know we're going to move forward with these efforts. And I just want to say to you, I've received several emails, and a couple of them from Washington, D.C., from people who want the recording. And I will say to Park and them, if they could please send the link out to various people. And I'd like to thank you both, and it's very enlightening, and we will have you back. And I miss you, the students miss you, and we would love to see you again on campus. And I'd like to thank our audience. I'd like to thank our communications department, Teresa Johnson, and everyone else. So thank you. We must continue to fight. Don't give up. Have a great night.